Hi, Phillip Rompotis here. I'm a partner in the Arbitration and Litigation Group of Stephenson Harwood in Hong Kong. Welcome to Arbitration Week, and I hope you enjoy the video. Look, foreign investment is an important factor in all economic development for most nations. It provides access to capital and provides access for essential infrastructure such as roads and airports and sewage plants, power plants, etc. Now, the investment climate is affected by a range of factors for most investing companies, including political factors and economic factors. And it's also affected by the legal framework within that country, and that includes the way that country resolves its disputes. And essentially this is where investment arbitration comes in. And what it does provide is an international forum for the resolution of disputes. In other words, removing the resolution of disputes from the domestic courts. Well, first thing, I think we need to acknowledge that there are advantages and disadvantages for both the investor and the host nation. Looking first from the investor's point of view, the key point, it seems to me, is that it gives the investor a level of legal security in knowing that there is an independent forum for resolution of its disputes. It also, for the investor, provides a level of protection from domestic issues. For example, where there are risky countries from the point of view of nationalisation, privatisation, and also from the possibility of a biased or unreliable judicial system. Similarly, for the host country, it provides some advantages. For example, it provides a climate for investment, and that's very important to attract investment and to increase confidence in the host nation. It also affords the host nation a level of protection in the same way as it does the investor. For example, it shields it from diplomatic pressure from other countries, etc. Similarly to advantages, there are also disadvantages to both parties. And for example, both parties take the risk in investor-state arbitration as a party would in any other arbitration. And for example, that involves high costs, it involves the length of time to resolve a dispute, it involves the uncertainty of the result. And in investor-state arbitration in particular, there is a particular procedure which has become increasingly, there's been an increasing trend in recent years to introduce third parties into investor-state arbitration. And again, that is a potential risk for both the investor and the host nation. From the investor's point of view specifically, there can be a loss of confidentiality in investor-state arbitration, particularly where the arbitration is conducted under the auspices of the ICSID, which allows for a broader publication of awards, hearings, etc. Okay. From the host nation's point of view, of course, having something public gives rise to a potential that the failings of government are brought out into the public. For example, the incompetence of any government officials or any capricious behaviour by the government. Okay, let's deal first with confidentiality, and it's important to note that clearly confidentiality is a key component to arbitration proceedings and has been regarded and is regarded as one of the key advantages to private arbitrations. Now, when we transpose that into investor-state arbitrations, what we see is the similar types of advantages in that context. So for example, where something is confidential in an investor-state context, you get a protection of commercial interests which might otherwise be abused by other parties, competitors of the investor, etc. There is also, from an investor's point of view, a protection of their reputation and public image where things are kept confidential. Furthermore, and this is more a practical point, there is a possibility where matters are kept confidential, that the tensions between the parties can be reduced, thereby facilitating the possibility of a settlement and thereby saving time and costs. Now, moving on to disadvantages, similarly, the advantages that are evident in private arbitrations can be seen to apply in investor-state arbitrations. I referred to two main points, for example. A big disadvantage is the absence of an evolution of legal precedent. And this is a real problem because at the moment, most arbitrations are conducted in a confidential manner, which precludes the evolution of a body of law which can be used as precedent in further and subsequent cases. It often involves, therefore, the reinvention of a will by the arbitration tribunal and the lack of certainty from an investor's point of view when making an investment into a host nation. Moving now on to transparency. Traditionally, investor-state arbitrations have been as confidential as any other private arbitrations. However, the definite trend over the last decade or so is to make investor-state arbitrations more transparent. And this manifests itself, for example, in both the production of documents and in the involvement of other parties. Now there are some benefits, obviously, to having greater transparency. The first and foremost point to make is that it provides for good governance. Effectively, the right of a party to know what its government is doing. And that, simply put, is that since the dispute involves the state, since that dispute involves public officials, and since that dispute involves public money, then the public has a right to know. It also helps from a consistency of approach point of view, and it assists investors in understanding the risks involved when entering and investing into a host nation. This element of being able to accurately assess a risk, an investment risk, before entering into a host nation is a very, very important aspect to a decision by a company to go into a host nation. Furthermore, there is an element of pressure when it comes to enforcement of arbitration awards, where there is a greater level of transparency. And by that I mean that where a party has obtained an arbitration award and seeks to enforce that award, then by virtue of it having been transparent, there is a level of pressure on the government to actually pay or to not make any application to resist enforcement. And again, that aids both in terms of saving time and in costs for the foreign investor. Perhaps one of the greatest advantages to transparency is the point I made earlier about the evolution of a consistent body of law. The concept of precedent, which is very well known in a common law world, but is largely absent from private arbitrations. And what that does is very simply gives the parties, both the investor and the host nation, a level of legal certainty that it will be treated the same as the party before it. Now, of course, there are also disadvantages to transparency, and I refer to two main ones here. The first one, of course, is the potential loss of investment by making it transparent. Commercial parties tend to want to keep their business to themselves. They are motivated by profit, and they enter into an agreement to do something in another country for the sole purpose, usually, to make money. The idea that, the possibility that their dispute may be made public may well act as a disincentive for them to get involved in foreign investment. The second main disadvantage that I will deal with is the intervention, or the possibility of intervention, by third parties, what is known as the amicus curiae. This is where a third party, not a party to the arbitration or the dispute, it gets involved in the arbitration for the purpose of presenting its view. Now, this has obvious advantages, particularly where public interest is involved, things such as environmental damage, etc., or civil rights, for example, but it also has disadvantages. It increases the time, the cost, and the level of uncertainty in resolving a dispute. Now, This will evolve over time, and some rules allow for third parties to be involved. And at the moment, it is largely up to the tribunal to decide who can and who can't get involved in these arbitrations. The Asian region contains a large portion of the world's population. The economies in Asia, the various economies in Asia, are in different stages of development. There is a significant need in many countries within the Asian region for foreign investment. There are roads to be built, bridges, tunnels, sewerage plants, energy plants, telecommunication services, etc. Particularly in economies that are developing, where there is still a lot of infrastructure investment to be made. Countries such as Indonesia and Malaysia are prime examples to that. Now, foreign investors are motivated by profit, and there are many opportunities for them to take advantage of opportunities in this region and to prosper financially, and at the same time to offer a product and a service that is required by that country. As I see it, the future investment arbitration in Asia is bright. There is, as I said, a lot of investment to be made in this region, and as a corollary to that, there will be a large number of disputes and large and complex disputes that need to be resolved. So I see this area of law and this area of practice increasing as we go forward.